All right, I am going to read to you a very long federal complaint, a very long lawsuit. Um, I'll wait until a few more people get on board here. Also, you can read it yourself, and I'll show you where. This is where you can find the lawsuit, I guess I'll say this throughout the show so that you'll be able to find it. And read it yourself to go back over something. Bernie.substack.com. You will see a lot of articles. That's what it is. It's a place to post articles and videos. And Bernie.substack.com. It's also, if you subscribe, you get your weekend newsletter, email newsletter. And it's free. Highly recommend you do that. It takes like 20 seconds. Bernie.substack.com. Never miss a show. And or the posts. It's all in one place. Bernie.substack.com. That's where you'll be able to read this for yourself. Also, I will tell you this is fairly long, but there are ways for me to cut corners, at least when I read it, because some things are sort of duplicated. There are 18 counts in this lawsuit, and there are 10 defendants in the lawsuit. You're about to see it all. And so I'm going to read it straight through without my usual histrionics, right? Without all the normal stuff I do. I'm going to try to read this like Mr. Spock rather than Captain Kirk, which is who I'm more like. All right. So if and another reason I'm going to read it straight through without commentary is because this is a federal lawsuit. And out of respect for the court and the process, I'm going to treat it that way. Because when this happens, when constitutional rights are violated, this is all we have, right? So I want to be respectful to the process. I will try to look at comments periodically, but I'm going to be doing a lot of reading. And another reason that I want to share this with you, first of all, I could do this every night. There are, like, I don't know the exact number, but there are something like 25 lawsuits against Sheriff Tommy Ford. Yeah. And if the deputies and the sheriff acted anything like they did in this case, there probably should be more. But I'm going to read this straight through. I do want to sort of, I always joke around, jokingly say I'm Bernie the attorney. I'm not. Our attorney is Marie Maddox. That's who is representing us in this federal lawsuit. But I have been able to learn a few things. All right. So I want to explain to you first, as we go along a little bit for educational purposes as well. All right. Why don't we get to it? This was filed on August 6th in federal court. We are suing all of them, 10 defendants. Tommy Ford in his official capacity as Sheriff, Bay County, the city of Panama City, and you'll see why. Jimmy Stanford individually. These are all officers. These are all deputies and executive staff or were. Jimmy Stanford individually, Nicholas Macias individually, Alvin Eiler individually, Stephen Reinhart individually, Ryan Nelson individually, Krista Chastain individually, and Richard Thor individually. I probably should show you the video and show you where you can see this. It's like a minute and a half, but it's probably necessary. I'm not going to do it. I'm going to just read on. Okay. I'm just going to read on. I know it would be better if you saw it, but if you go to bernie.substack.com, you can see the short video or even on this page. Let's get on with it. So 10 defendants, the complaint just says we're suing them. The nature of the action is it's a federal lawsuit. It's it's called a 1983, 42 U.S. Code 1983. That means you can file a federal lawsuit against state actors who violate your constitutional rights under the color of law. All right, so that's what this is. All right, And the parties are all, this is all in the right jurisdiction. It's all pled properly. It meets all the rules. That's what all this stuff here is. And then this is where it begins on page 4. Plaintiffs' background, the ultimate statement of facts, they call this. So you have different parts of a lawsuit. You have the facts, then you have the counts and the arguments, and they sort of work together. All right, but let's go over the facts. Plaintiff's background and prior relationship with the Bay County Sheriff's Office. The instant matter involves a shocking turn of events in which wherein trusted citizens with a media outlet went from assisting law enforcement in announcing the clarion call against corruption to becoming victims of corruption themselves at the hands of the very law enforcement agency, Bay County Sheriff's Office, who plaintiffs once thought intended to stamp corruption out. Plaintiff Bernie Thompson is a well-known independent media figure, political commentator in Bay County, Florida. He's hosted the, again, I'm going to avoid the jokes. I've already have the urges to do this, but I want to try and do this straight through. He has hosted the Bernie Thompson Show since 2007, and since 2015 has focused on watchdog journalism, reporting on matters of public concern, including public corruption and local government abuse. Plaintiff Sarah Moon provides essential research and content for Plaintiff Thompson's show. Her contributions include investigative work into political and law enforcement misconduct in Bay County. She also makes frequent comments and shares the show on her personal Facebook page. Plaintiff Thompson often refers to her as the brains behind the outfit. Now it's official, under oath. I said I'd stop, wouldn't do that. Plaintiff Thompson and Plaintiff Moon, husband and wife, have lived in the same home since 2015 and were married this year. Between 2017 and May 2022, plaintiffs, us, maintained a cooperative relationship with Bay County Sheriff's Office Chief Deputy Joel Heap and Major Jimmy Stanford. The parties routinely exchanged information regarding public corruption, including during a joint BCSO FBI investigation that led to high-profile indictments and arrests. This relationship ended abruptly on May 4, 2022, when Heap and Stanford confronted Plaintiff Thompson at his office, expressing hostility over his recent reporting of the Lynn Haven, Florida corruption case involving James Finch of Phoenix Construction and former Lynn Haven Mayor Margo Anderson. During the criminal proceedings in that case, allegations involving Major Stanford's acceptance of gifts, including a motorcycle, from a local developer who was under investigation came to light and called into question his integrity as an investigator and the integrity of BCSO, Bay County Sheriff's Office, as a whole. Part 2 of the statement of facts. Retaliation for journalistic news gathering and source contact. On January 6, 2022, this all happened 3 years ago. Statute of limitations to file a federal lawsuit of this nature in Florida is 4 years. So we're well within that. In California, it's only 2 years. All right. On January 6, 2022, Plaintiff Thompson communicated with Mayor Anderson via Facebook Messenger to discuss newly filed court documents in the federal prosecution against her. During the conversation, which occurred at approximately 2:33 p.m., Anderson disclosed information supporting Plaintiff Thompson's ongoing investigation into misconduct by BCSO officials, including evidence that indicated Stanford had maliciously targeted Anderson for prosecution. Just hours later, at approximately 4:39 p.m., Corporal Nick Macias, an officer under the direct command of Stanford, accessed Plaintiff Thompson's personal information in the federal, Florida, FCIC, and national NCIC law enforcement databases. Plaintiff was not under investigation, was not suspected of any crime, and had no interactions with law enforcement that would justify such a search. Upon information and belief, this search was not investigatory in nature, but was instead initiated or encouraged by Stanford in retaliation for Plaintiff Thompson's protected journalistic activity, specifically his communication with Anderson, which was made for the purpose of gathering information which was of great importance to the public. This retaliatory surveillance by BCSO personnel, including Macias, who was under Stanford's supervision, was intended to intimidate plaintiff, discourage his continued reporting, and find pretext with which to punish him for seeking out sources critical of the sheriff's office. In the months leading up to the unconstitutional search of plaintiff's home on August 19, 2022, Plaintiff Thompson repeatedly exercised his First Amendment rights by reporting on public corruption and criticizing the conduct of the sheriff's office. His commentary, widely followed by the public, drew increasing hostility from the sheriff's office leadership. On April 6, so the raid on our house was August 19th, so a few months before that, April 6, Plaintiff Thompson published a post after leaving the federal courthouse in Tallahassee, where he predicted that charges in the Lynn Haven corruption case might be dismissed. He warned, "Don't be shocked if the entire case collapsed because of the misconduct of investigators." On April 28, Plaintiff Thompson posted that BCSO's investigation into Finch and Anderson appeared to be malicious prosecution. He accused law enforcement and prosecutors of making false statements to a grand jury, manipulating evidence, and seeking to avoid trial to conceal their misconduct. Plaintiff also criticized local media for their biased coverage. On May 4, just the next week, Chief Deputy Joel Heap and Major Stanford confronted Plaintiff Thompson in person at his office and expressed anger about his reporting. After that meeting, they severed their relationship with him. On July 8, Plaintiff Thompson published another post reporting that U.S. District Judge Mark Walker had rebuked investigators in the Lynn Haven case as reckless and haphazard, publicly validating Thompson's earlier scrutiny of BCSO. On August 11, Plaintiff Thompson published a bombshell report regarding a newly unsealed FBI affidavit. The post alleged that local corruption extended to the Bay County Commission, Bay District schools, and other officials. Thompson criticized Sheriff Ford for continuing to endorse one of the implicated officials, Griff Griffiths, in his campaign for state representative. On August 16, just 3 days before the raid on our home, Thompson reported that the same affidavit had been resealed and suggested that federal and local officials were trying to protect public figures by obstructing transparency and delaying justice. These posts prompted increasing animosity from BCSO officials just 3 days after his August 16 post. BCSO deputies teamed with a Panama City Police Department officer to unlawfully enter plaintiff's backyard without a warrant on August 9th, 2022. This entry was not supported by a search warrant, exigent circumstances, or legal justification, and was conducted in retaliation for Plaintiff Thompson's protected speech activities and in violation of the Fourth Amendment to the Constitution. All right, we're still in the statement of facts. Warrantless entry and harassment at plaintiff's home. On August 19 at approximately 4:40 p.m., 6 BCSO deputies led by Sergeant Stephen Reinhardt and joined by Panama City Police Department Lieutenant Thor arrived at plaintiff's residence in Panama City Beach, Florida. They did not possess a warrant, nor were any exigent circumstances present, and no consent was sought by or given to them. Upon information and belief, City of Panama City Police Chief Mark Smith, in his capacity as final policymaker, ratified, delegated to, or failed to discipline unlawful conduct by his subordinates, including but not limited to Thor. Upon arrival to plaintiff's residence, Reinhardt knocked on the front door flanked by Wilson, Nelson, Chastain, and Thor. When Plaintiff Moon came to the door, she answered questions and realized she was not free to leave, as her driveway was blocked by law enforcement vehicles. For approximately 10 minutes, Plaintiff Moon was interrogated by Reinhardt, Nelson, Chastain, and Thor. They questioned her about allegedly stolen AirPods. No such item had been reported stolen until nearly an hour after they had already entered the plaintiff's property. In other words, nobody called the cops on us until after. Let that sink in. When Plaintiff Moon showed the deputies video of someone knocking on the home's front door earlier, Thor suspiciously stated that he had told the deputies that they had the wrong home. All the while, unbeknownst to Plaintiff Moon, Macias and Eiler entered plaintiff's enclosed backyard by opening a wooden gate while she was distracted with the questioning from Reinhardt, Thor, Nelson, and Chastain, who were speaking to her at the front door. The entry was captured on Macias's body-worn camera. The backyard, part of the protected curtilage, contained personal property and was clearly intended to be private. Plaintiff Moon expressed fear and humiliation during the encounter, which was witnessed by onlooking neighbors. Pretext and advance coordination. Prior to the raid, Reinhardt coordinated with Lieutenant Thor, plaintiff's neighbor, who had aimed surveillance cameras at plaintiff's backyard. Thor told plaintiffs he records all comings and goings in the neighborhood. Thor was thus aware that Plaintiff Moon was home at the time of the search. Reinhardt communicated with deputies through WhatsApp to coordinate the operation. Remember, it was at 4:40. So earlier at 4:09 p.m., Reinhardt notified deputies that he was confirming plaintiff's address with Corporal Amy Burnett and the alleged burglary victim, despite having the evidence implicating juvenile suspects elsewhere. In other words, before they got to our home, the sheriff's office already had identified suspects, and it wasn't us. All right. Keep it straight, Bern. Earlier that day, the alleged victim, Zach Rourke, banged on plaintiff's door, claiming to have tracked AirPods to their house, but later told deputies he retrieved them from a different home. Records show that Rourke did not formally report the theft until after the search at plaintiff's home had already taken place. Following the incident at plaintiff's home, deputies arrested two juveniles, Jamie Crawford and Richard Baker III, in a nearby area on charges connected to the crime for which plaintiff's home was being searched. Upon information and belief, the arrest of both Crawford and Baker was staged by defendants in a scheme to cover up the unlawful search conducted at plaintiff's residence. Discovery will be very interesting. I will tell you this, and this is going to come later in the lawsuit. I'll read it to you, but you'll at least know what I'm talking about by that point. Sheriff Ford told us that the 16-year-old and 17-year-old, both adults now, that it was confidential juvenile information, couldn't give us the information. But we always wondered why Sheriff Ford will post juveniles, 15, 16, 17-year-olds a lot, and put their faces up and their names up there on the sheriff's Facebook page. So why was this confidential juvenile information? Well, it wasn't, because this is the law. In Florida, if a juvenile commits a is charged with an act that would be a felony if an adult did it, then it is not confidential. So when you see Sheriff Ford's page posting juveniles and their names and their faces, it's because they've been charged with a felony, and it's not confidential. It's public, according to the state statute. But in our case, Sheriff Ford told us that they had chased these two teenagers out of our neighborhood after they got the wrong house, ours, and they got a gun off of them and other stuff. And they even had to have a canine go get them because they ran away. But even though Sheriff Ford said that they got a gun off of these two teenagers that ran out of our neighborhood, he only charged both of them with misdemeanors, with resisting an officer without violence. That wasn't true. That wasn't true at all. But they never thought we would find out their names. We did. How? From the sheriff's office. You see, they don't know this yet, so I'll give them some help in the lawsuit. Krista Chastain, investigator Krista Chastain, she did a victim sworn statement the following week. And in this victim sworn statement, the written transcript redacted improperly and illegally, redacted the names of the two minors, who, by the way, are now doing time. And I'm not sure they should be. All right, I said I wasn't going to get into too much commentary, but we got their names initially from investigator Krista Chastain, who improperly redacted the written transcript, but you could hear it in the audio interview. She says their names out loud. That's how I first got their names. But we also got information from Panama City. Remember, it was a joint operation. They gave us their names because the juveniles at the time were charged with felonies. So it's not confidential juvenile information. That's part of our lawsuit. All right, so that's what that's about. Evidence misconduct and public records obstruction. Plaintiffs filed several public record requests and an internal affairs complaint after the incident. In March 2023, Sheriff Ford ultimately ruled that the complaint was not sustained and the deputies were exonerated. BCSO delayed or denied record disclosures, redacted juveniles' names despite statutory exceptions under Florida law, and withheld body camera footage or altered transcripts to omit key details in an effort to obscure their actions. Multiple items recovered during the arrest of the juveniles, some allegedly seized days before they were reported stolen, were logged under questionable entries and or attributed to incorrect victims by Nelson, Eiler, Chastain, and Reinhardt. Later in March 2023, defendant Major Jimmy Stanford sent a text message asking Plaintiff Thompson to call him on the phone. When Plaintiff Thompson called Stanford, Stanford launched into an aggressive and unprofessional outburst. Stanford called Plaintiff Thompson a liar for his reporting during the Lynn Haven prosecution, which was still underway. The height of it, really. Stanford was especially angry at Plaintiff Thompson's coverage of Stanford's acceptance of gifts from a local contractor who, through court documents and evidentiary hearings, had been revealed to be a target of another investigation. This call confirms Stanford's personal animus toward plaintiff. Stanford's animus highlights a direct causal link between plaintiff's protected reporting and the adverse consequences Stanford suffered from his lead role in the Lynn Haven corruption case. The call further supports the inference that Stanford had both motive and opportunity to direct and or encourage retaliatory acts against plaintiff, beginning with the January 6, 2022 unlawful database search and culminating in the August 2022 warrantless raid of plaintiff's home. Plaintiffs have retained the undersigned attorney, which is Marie Maddox, to represent their interests in this cause and is obligated to pay a fee for these services. Defendant should be made to pay said fee under laws referenced above. Okay, now I'm going to tell you the 18 counts. Now that you have the ultimate statement of facts, I'm going to name for you all 18 counts. But first, let me thank sponsors, catch my breath, and we'll get right back at it.
You want to look good? You want to feel good? Little John's Big and Tall is where it's at. Right across the street from Sky's Pizza Pie, 5700 North Davis Highway. You can find out more online at littlejohnsbigandtall.com. He's also a member of the iTex trading community, where your iTex dollars are welcome. Don't let back pain and neck pain get you down. Find relief at Brown Chiropractic Center on St. Andrews Boulevard in Panama City. Dr. Sherry Brown helps people heal naturally with chiropractic adjustments and deep tissue massage. Call 769-377.
Strong, effective leadership. 3 words that could mean the difference between prison and your freedom. I'm Al Saleen, your Panama City Beach lawyer. 850-215-0628.
All right, again, I want to remind you that you can read all of this yourself and take your time. It's at bernie.substack.com. Bernie.substack.com. That's where you can read it. It's a bunch of articles, and in there you'll see it's easy to find. All right, so I've read to you our statement of facts as we have pled. Now let's get to the counts. Count 1. And what I'm going to do is tell you that counts 1, 2, and 3 are the same. They just have different parties. Okay. So we'll be able to get through this. This is how I'm going to kind of, get through this a little faster than reading every single one completely, because the meat and potatoes of each count are pretty much the same. The legal standard and the case law and the arguments and all that stuff. So counts 1, 2, and 3 are Fourth Amendment violation, unconstitutional search and seizure. Count 1 is against all defendants. Count 2 is against the sheriff's office. And count 3 is against Panama City Police Department. This count, is against all of the individuals, Reinhardt, Macias, Eiler, Thor, Nelson, Chastain, and Stanford individually, for unconstitutional search and seizure under the Fourth Amendment to the United States Constitution. Each of those defendants entered or caused to be entered plaintiff's curtilage. So if you don't know that word, curtilage is a very important word. And the case law in this, by the way, in Florida, it's a federal lawsuit, but in the 11th Circuit in this area is a case called Jardines. And basically the curtilage is like your home's personal space. So if your backyard is enclosed with a gate and a fence and you can't see back there, and in the backyard it's maybe got chairs and a barbecue grill and it's private, that's your curtilage. That is exactly, according to the Supreme Court and the case law I just mentioned, Jardines, for law enforcement to open a gate and go into a enclosed backyard like that is exactly, for Fourth Amendment purposes, like opening your door and walking into your home. It is exactly the same thing. And that's what they did. So that's what curtilage is. Specifically, the enclosed latch backyard of plaintiff's private residence without a warrant, without exigent circumstances, and without plaintiff's consent. The unlawful entry and search were conducted in retaliation for plaintiff Bernie Thompson's protected First Amendment activity and under pretextual circumstances not supported by probable cause or any lawful investigative purpose. Defendant Macias and defendant Eiler physically entered the curtilage. Defendant Reinhardt directed the operation and misrepresented the facts of the alleged theft used to justify the search. Defendants Thor, Nelson, and Chastain participated in the unlawful seizure of plaintiff Sarah Moon's liberty by detaining her at her front door without legal justification. Defendant Stanford directed, encouraged, or approved the conduct of his subordinates in retaliation for plaintiff's journalism. The violations of plaintiff's Fourth Amendment rights were the type and character as to which any reasonable law enforcement officer would be aware. Each defendant acted in bad faith and with malicious purpose, and in a manner exhibiting wanton and willful disregard of human rights, safety, property. Defendants are not entitled to qualified immunity. Based upon the facts presented to each defendant and the applicable law, no reasonable law enforcement officer could have concluded that there existed any legal basis to enter plaintiff's enclosed backyard or to detain Plaintiff Moon without a warrant or exigent circumstances. The law was well settled and clearly established that such actions constituted an unlawful search and seizure under the Fourth Amendment. The actions and inactions of each defendant, as set forth in part above, constitute deliberate indifference or reckless disregard for the safety and constitutional rights of plaintiffs, and defendants knew of and disregarded substantial risk of unlawful harm. Each defendant misused power possessed by virtue of state law and made possible only because they were clothed with the authority of state law. The violations of plaintiffs' rights, as described above, occurred under the color of state law and are actionable under 42 U.S. Code, Section 1983. As direct and proximate cause of defendants' actions, plaintiffs have been damaged, which damages include grave mental anguish, pain and suffering, loss of capacity for the enjoyment of life, embarrassment, humiliation, loss of reputation, and the loss of other emoluments. If you know Sarah Moon, ask her to say emoluments. But don't ask her to say the word emoluments if you're drinking coffee or anything. Okay? There's some words I have a hard time saying. I'm going to be in so much trouble. The brains behind the outfit. These damages have occurred at present, in the past, and will most likely occur in the future. You know, well, I'll just tell you, since we're all here together. You'd be surprised how much people who know me know. Did you see my phone call with Tony Bostic? If you did my demeanor sort of surprise you? My language, my I don't know, passion, the way it's not the way I talk to somebody, especially a man who we disagree maybe in private, is different than what I present to you. And so you wouldn't believe the loss of sleep and all. I don't want to get into all that for reasons. It's embarrassing, first of all, but the constant worry of everything you do being under surveillance, of everywhere you go, catching vehicles. I've got a lot of videos. You'll see them eventually. You know, and I know I choose this, but nobody deserves to have their constitutional rights deprived and then be in constant fear to stand up against those who did it. It takes a toll. Okay. So enough of that. I just wanted to express that to you because I know these things have happened a lot worse to many of you. And I care about it. I'm going to keep going here. I could go on, and I could tell you so many things about this very event that you wouldn't believe, but I'm going to press on here, okay? So counts 1, 2, and 3 are the same. It's just the defendants are different. Count 1 is the individuals. Count 2, Fourth Amendment, is sheriff's office, and count 3 is against Panama City Police. And so this is what's important, however, about count 2 is those of you who know law will find this interesting, okay? Let's see. Defendant Stanford encouraged or approved the conduct of his subordinates in retaliation for plaintiff's journalism. Alternatively, Stanford failed to intervene or supervise despite a known risk of constitutional violations, including prior misuse of law enforcement databases by Macias under his command, Stanford's. Upon information and belief, Stanford was a final policymaker or was delegated final policymaking authority by the Bay County Sheriff with respect to investigations and tactical operations. He was the supervisor over all investigations and patrol. He was the number 3 under Chief Deputy Joel Heap. The 2 that came to my office and yelled at me for 2 hours, but I told you about that. All right. So because he's so high up, we argue that his actions are independently attributable to the municipality under Monell. Monell is case law. Defendant BCSO is liable under Monell for the unconstitutional actions of its employees and decision makers. Plaintiffs allege, we argue, that the unlawful search was undertaken pursuant to a pattern and practice of retaliatory and unconstitutional enforcement actions against critics of the department. BCSO either maintained a policy, tolerated a custom, or failed to train and supervise its deputies in a manner that caused the constitutional violations suffered by plaintiffs. The actions or inactions, okay, that goes on, and number 3 is also the same. What did I highlight here? Okay, so why is Panama City Police being sued for Fourth Amendment violations? Well, because of their lieutenant at the time, Rich Thor, our neighbor. It was a joint operation between Panama City and Bay County Sheriff's Office. Defendant Panama City Police Department is liable under Monell for its participation in and acquiescence to the retaliatory conduct. Thor's participation in the raid, surveillance of plaintiff's property, and unlawful questioning of Plaintiff Moon were undertaken in furtherance of a joint scheme of retaliation against plaintiffs and without corrective action by PCPD leadership. And PCPD's failure to supervise or discipline Thor supports an inference of policy or custom of constitutional indifference through its final policymaker, Police Chief Mark Smith. And let's get to count 4 now. All right. First Amendment retaliation. This count is against all individuals. The defendants unlawfully targeted Bernie Thompson, his protected journalistic speech, and Plaintiff Moon's research, investigation, and reporting in support thereof. Plaintiff Thompson has engaged in core protected activity by reporting on public corruption in Bay County and specifically criticizing BCSO and PCPD officials, including Stanford and others, for misconduct. These reports garnered public attention and disapproval from high-ranking officials in the agencies named. Plaintiff Moon participated in this protected speech by conducting research and producing reports for publication for the Bernie Thompson Show. Her contributions formed part of the protected journalistic enterprise targeted by defendants. In retaliation, defendant Stanford directed or encouraged subordinates, including Macias, to initiate intrusive and unlawful action against plaintiffs. On January 6, just hours after Thompson spoke with Mayor Anderson, regarding Stanford's alleged misconduct, Macias, acting under Stanford's command, accessed Thompson's personal data in the FCIC-NCIC database without cause. Stanford later confirmed his personal animus toward Thompson during the visit in May 2022, but also in March of 2023 in a phone call in which he called Thompson a liar for reporting that Stanford received gifts from a contractor who was under investigation. All right. Oh, this is very important. Bay County Sheriff's Sergeant Reinhardt, he's the guy in the purple shirt standing at the door who knocked on the door and asked my wife to step outside. He orchestrated the August 19, 2022 raid, coordinating with our neighbor, defendant Thor, via Panama City Police, via phone, staging a pretextual basis for the search. Defendants Nelson and Chastain assisted in the unlawful detention and questioning of Moon, while defendants Macias and Eiler entered the home's enclosed backyard, protected space, without warrant or exigency. The entry, seizure, and intimidation tactics were 14. I count 14 units in our neighborhood. Intimidation used by these defendants were the culmination of months of escalating retaliation for plaintiffs' protected speech. The retaliatory conduct of each defendant was intended to chill plaintiff's speech, dissuade them from further reporting, and punish them for exposing misconduct by law enforcement. The conduct lacked any legitimate investigative purpose and was driven by animus toward plaintiff's exercise of protected rights. All right, so then it goes on to everybody, all the law enforcement officers should have known, any reasonable officer would know, their actions damaged us, and that's First Amendment retaliation, basically saying that they violated our Fourth Amendment rights because they were angry at my reporting. And they acted on it. And that's what the First Amendment retaliation is. That's sort of what you have to, and that's counts 4, 5, and 6. So let's get to count 7 here. All right, here we go. Count 7. 14th Amendment violation. Deliberate falsification and concealment of evidence. This is big. All right. This count sets forth claims, again, 1983, a pattern of deliberate falsification, concealment, and manipulation of material evidence and public records for the purpose of covering up unlawful conduct. Upon information and belief, after unlawfully entering plaintiff's home and backyard without a warrant, defendants staged the arrest of 2 juveniles, Jamie Crawford and Richard Baker III, in connection with the alleged AirPod theft, despite no formal report of theft having been filed until after the search at plaintiff's residence. The arrests were timed and coordinated to falsely justify the unconstitutional search and fabricate a post hoc narrative of lawfulness. Following these arrests, defendants jointly participated in a deliberate effort to conceal or distort key facts and evidence. Nelson, Eiler, Chastain, and Reinhart misattributed recovered property to the arrested juveniles, including items allegedly seized before they were even stolen. Although Stanford was not physically at the scene of the arrest or search, he had a documented retaliatory motive against plaintiffs, expressed direct animus during a May 22 argument and during a March 2023 phone call, and held supervisory and policy-making authority within BCSO. Stanford either ordered or ratified the falsification efforts, or at minimum, knowingly permitted them to proceed unchecked. Stanford even participated in a post hoc cover-up when on September 9, 3 weeks after the raid, Stanford joined Sheriff Ford and Captain Jason Daffin during an hour-long meeting with plaintiffs in which he alleged that somebody gave him a tip. That's what gave rise to the probable cause and exigent circumstances which justified the raid on plaintiff's home. In other words, nobody called the police and said their AirPods were stolen. They got a tip. Now, after, about almost an hour after they searched our home, the guy who had banged on our door earlier, they decided to call 911 and report missing AirPods almost an hour after they raided our home. The conduct described herein violate clearly established constitutional rights, and because no reasonable officer could have believed that their actions as alleged herein were lawful under the circumstances, defendants are not entitled to qualified immunity. And it goes on to the damages, and that's the 14th Amendment. Violation is deliberate falsification and concealment of evidence. A lot. Discovery will be a shocker for you. And I want to say this too. I am not going to be, out of respect for the federal court and for the whole process, because this is the only way we can respond to what they did. When it comes to this, while the case is happening, while the lawsuit's going, I will tell you what the facts are that we can do, but I'm not going to, I don't want the court or the defendants to feel as though, I want them to be comfortable to tell under oath what happened. I want this to be a good process. I want the court and the public and everybody to say, this is how you deal with it. This is the right way to go. And especially when the lawsuit is still active. All right. So let's get to count. Let's get to count. What would it be? Where are we at? 9? What's after 14th Amendment? Oh, look at that. Another 14th Amendment count. This one is equal protection. And again, this is against, this will be counts. Let's see, this will be counts 9, 10, 10, 11, 12, I believe. Anyway, it's again, each one of these is one is against the sheriff's office, one is against all individuals, and one is against Panama City. Okay, this defendants were unlawfully targeted plaintiff's home for a warrantless search and seizure, despite having no probable cause, exigent circumstances, or consent to justify the entry. Plaintiffs were singled out and treated differently than similarly situated individuals. Okay, I'm going to try to get through this. The decision to single out plaintiffs was rooted in unlawful discrimination and personal animus. Plaintiff Thompson's prior criticism of BCSO and PCPD, along with his protected journalistic reporting, drew escalating hostility from law enforcement. Plaintiff Moon, by virtue of her critical commentary, you know all this already. We've gone over this stuff. Again, the conduct of the officers, no reasonable officer acting under the law would have done these things. Therefore, they're not entitled to qualified immunity. And then the damages, let's see, what's the next count after 14th Amendment? Equal protection. All right. Now we are on count 12. Failure to supervise. It is a Monell claim. Again, Monell is case law. Monell liability against the Bay County Sheriff's Office. This is basically saying that the sheriff has customs and policies, even if they're not written down, even if they're not official, that allow this stuff. And people who violate constitutional rights under this custom or policy are not disciplined. That's what this is saying. Let's read it, though. The final policymaker, Sheriff Ford, maintained and tolerated a policy, custom, or practice of failing to supervise employees with known propensities for misconduct, specifically defendant Stanford. Despite Stanford's well-documented misconduct, including criminal gift-related violations revealed in the Margot Anderson corruption prosecution, Bay County Sheriff's Office failed to take any disciplinary action or remove his authority. Instead, BCSO retained Stanford in a supervisory capacity. allowing him to direct or participate in operations that violated the constitutional rights of citizens, including plaintiffs. This failure to supervise Stanford directly resulted in his involvement and orchestration of the unlawful entry, search, cover-up, and conspiracy at plaintiff's home. BCSO is liable under federal law, 1983, Section 1983, pursuant to one or more theories of Monell liability, again, case law, an official policy ratified or approved by final policymaker, or a widespread and well-settled custom or usage, or deliberate indifference in the failure to train or supervise, or ratification of unconstitutional conduct after the fact, or delegation of final policymaking authority to Stanford. And as a result, plaintiffs were damaged. That also, the Monell failure to supervise Monell liability also goes, count 13 is against Panama City Police Department. Count 14, abuse of process. All right. This is, I believe let's see, this might be the first one. Failure to supervise, is federal. So we are able to put, there are a couple of counts in civil law, they're counts, and criminal law, they're charges, right? So this is civil law. So we are able to bring state counts in a federal lawsuit, but you cannot bring federal counts into a state lawsuit. So we have incorporated a couple, 2 or 3 maybe, state counts against them. And one of them is abuse of process. This is an action under Florida common law for abuse of process. Plaintiffs assert this count against defendants Reinhart, Macias, Eiler, Thor, Nelson, Chastain, and Stanford. On or about August 19, it was on, we know, Friday, 4:40, defendants initiated and or used legal process, namely a purported criminal investigation involving allegedly stolen AirPods and the arrest of 2 juveniles as a pretext to justify the warrantless search and retaliatory search of plaintiff's home in curtilage. Defendant Macias acted under the direction of Stanford and used the fabricated juvenile investigation as a means of targeting plaintiff's property. Macias arrived at a plaintiff's home with a team of law enforcement officers without a warrant or lawful purpose. Macias approached plaintiff's home without announcing himself and unlawfully entered their closed privacy gate and searched their backyard without a warrant, exigency, or consent. Defendants Chastain, Nelson, Reinhart, and Thor approached the front of the home and questioned Plaintiff Moon, intentionally distracting her while BCSO deputies encroached upon the backyard and curtilage without a warrant, exigency, or consent. While Plaintiff Moon was distracted and detained at the front of the property, defendants Eiler and Macias searched the backyard without a warrant, exigent circumstances, or any lawful justification. Defendant Chastain, she walked along the front of the yard and coordinated positioning with the other officers to facilitate the backyard intrusion under false pretenses. She also participated in the falsification of evidence and fabrication of the cover story to explain the unlawful presence. Defendant Stanford, although not physically present during the operation, was a supervisory authority over all involved and was aware and or approved the retaliatory plan. Stanford later engaged in a cover-up by permitting or encouraging the narrative that the officers had simply gone to the wrong address and arrested juveniles in a manner that falsely suggested an innocent mistake. Stanford had a known history of targeting Plaintiff Thompson due to public reporting, including exposés of Stanford's own misconduct. Stanford defendants Reinhart, Nelson, and Eiler coordinated the arrest of 2 juveniles after the fact. These arrests were used as a fabricated justification for the prior search against plaintiffs. The actions of all defendants were taken with malice, ulterior motive, and for an improper purpose, namely to punish plaintiffs for protected speech, shield themselves and public officials from accountability, and cover up constitutional violations under the guise of legitimate law enforcement operations. That is the state count of abusive process. Plaintiffs are entitled to punitive damages of each of the individuals under this count. All right, count 15. Again, state law this time. Under Florida common law against all defendants, trespass. This is a common law claim for trespass to real property against the individually named law enforcement defendants, as well as the Bay County Sheriff's Office and the Panama City Police Department. On August 19, 2022, defendants entered onto plaintiffs' private residential property in Panama City Beach, Florida, without a warrant, consent, and exigent circumstances, or any other lawful justification. Defendants Nelson, Thor, Chastain, Reinhardt approached the front of the residence, detained and questioned Plaintiff Moon to distract her from the illegal search being conducted in the plaintiff's backyard. Defendants Eiler and Macias entered the private and enclosed backyard and used it as a covert entry point to access plaintiff's home unlawfully. Defendants Thor and Nelson and Chastain, assisted by questioning Plaintiff Moon, along with Reinhardt and or remaining on the property in furtherance of the unlawful entry, despite knowing there was no valid basis. No valid legal basis for the intrusion. While Defendant Stanford, while not physically present on the scene, again, he was the top dog, orchestrated, approved, ratified. Stanford joined Sheriff Ford and Captain Daffin about 3 weeks later for an hour-long meeting with plaintiffs, during which they justified the raid by claiming probable cause and exigent circumstances. That's what Sheriff Ford and Captain Daffin and Major Stanford told us. 3 weeks later, we wanted to visit them and ask them why they did that. That's what they said. The entry onto plaintiff's real property was intentional, unauthorized, and without privilege, therefore, thereby constituting trespass under Florida law. All right. They're liable in their personal capacities if found to have acted outside the scope of their employment, and as a direct result, plaintiffs suffered damages. Okay, so 16. Count 16, there's 3 left, and the last 2 are, you're not going to want to miss the last 2, conspiracy. So I didn't know about this negligent retention. I learned this through the filing of this. Basically, what it's saying is that Sheriff Ford knew that Major Stanford had issues and negligently retained him in leadership positions. At all relevant times, Major Stanford was employed by the sheriff's office in a high-ranking supervisory role. He was number 3, and he was directly over all investigations and patrol. With final policy-making authority or authority delegated from the sheriff. Prior to the events giving rise to this lawsuit, Stanford had been implicated in misconduct, including but not limited to accepting gifts from a contractor who was under investigation. These facts became publicly known during the criminal prosecution of Margot Anderson. The aforementioned conduct constituted violations of professional standards, ethics, and potentially criminal laws, and were known or should have been known by the Bay County Sheriff's Office through reasonable diligence and internal accountability mechanisms. Despite this knowledge, Bay County Sheriff's Office continued to employ Stanford in a leadership position with significant decision-making authority over investigations and personnel. On August 19, 2022, under Stanford's direction and or tacit approval, deputies Macias, Eiler, Reinhardt, Nelson, and Chastain unlawfully entered plaintiff's property in Panama City Beach, Florida, detained Plaintiff Moon, and searched the enclosed backyard without any legal justification. During the prosecution of Margot Anderson, Stanford's retaliatory intent was displayed. On May 4, during the prosecution, the height of it in 2022, on May 4, when he traveled to Thompson's office to intimidate him regarding his coverage of the Lynnhaven case. Stanford's animus was later confirmed during the March 2023 phone call in which he called Thompson a liar and berated him for his journalism and coverage of the Lynnhaven corruption case, in which Stanford played a leading role. All right. As a direct and proximate result of the retention of Stanford, both plaintiffs were subjected to unlawful government intrusion, intimidation, humiliation, and the ongoing emotional distress, as well as chilling of their First Amendment rights. That'll be fleshed out during this case, okay? And that's going to be big. You say, Bernie, you don't look like you chilling on your First Amendment rights. All right, put a pin in that. The actions of BCSO in retaining Stanford, despite known or discoverable misconduct, constituted gross negligence and a wanton disregard for the plaintiff's safety and constitutional rights and others similarly situated. Okay, so now let's get to the conspiracy counts. One is a federal count, and that's this one. And then the other one is a state count. All right, count 17. Conspiracy to violate plaintiffs' clearly established constitutional rights under the First, Fourth, and 14th Amendments to the Constitution. At all relevant times, defendants Reinhart, Macias, Eiler, Thor, Nelson, Chastain, and Stanford agreed and acted in concert to violate the constitutional rights of plaintiffs Bernie Thompson and Sarah Moon. The conspiracy included, but was not limited to, conducting unlawful searches and trespasses at plaintiff's residence, initiating or allowing unlawful arrests and seizures without probable cause, falsifying or concealing material evidence, engaging in retaliatory actions against plaintiffs for exercising protected speech, and initiating or ratifying a cover-up by falsely attributing the illegal search to the arrest of juveniles. I'll wait till you see the discovery on that. All right. They approached plaintiff's residence under the pretense of investigating thefts and deliberately detained and distracted plaintiff Moon at her front door. Macias and Eiler entered the backyard unlawfully without a warrant, consent, or exigent circumstances. Stanford, though you've heard that already, not present, but he's the boss. As a result of the joint actions and omissions in furtherance of the conspiracy, plaintiffs were deprived of their rights under the Constitution, including the right to be free from unreasonable searches, seizures, and retaliation for protected speech. The acts of all defendants were done under the color of state law and were willful, wanton, malicious, and in reckless disregard. All right. Plaintiffs suffered damages. Now we're to the last count. Boy, I am worn out. Bernie, do you have calluses on your hands? Are you exhausted? I'm just telling you, I'm a little worn out. My voice especially. All right, let's get to the last one. Come on, wimp. Civil conspiracy under Florida common law. This is a state conspiracy count. Defendants agreed, all of them, explicitly or implicitly, at least two or all, to participate in a concerted scheme to violate plaintiffs' constitutional and legal rights, including through illegal searches, intimidation, false narratives, concealment of misconduct, abuse of legal process, and acts designed to chill protected speech. As part of the unlawful agreement and common design, Stanford despite not being physically present at the search, directed and or ratified the operation and its cover-up. Reinhardt and Thor, acting in concert with Nelson and Chastain and Eiler, approached plaintiff's home without a warrant, probable cause, or exigent circumstances and initiated the unlawful entry. Macias and Eiler entered the backyard of plaintiff's property without consent, justification, or legal authority. All these same defendants participated in the continued concealment of the misconduct, including the orchestrated arrests of juveniles to provide a false justification. All named defendants took steps to preserve the false narrative and retaliate against plaintiffs for their protected activities. These actions were not incidental to any legitimate investigation or law enforcement purpose, but rather intended to suppress plaintiffs' speech, intimidate them from further reporting and commentary, and conceal departmental wrongdoing. All right. No sovereign immunity. Plaintiffs are entitled to recover compensatory damages, costs, and such punitive damages as may be appropriate to punish and deter future misconduct. That is what is hoped for. So they don't do it to us or you ever again in their lives. Oh boy. All right. So what are we asking for? This is all legal stuff here. This is all like what do they call it? Cut and paste stuff. Let's see. Equitable relief, judgment against defendants awarding damages, judgment against plaintiffs permanently enjoining defendants from future violation. In other words, don't do it to us anymore. Enough with the unlawful surveillance and everything. Enter judgment against defendants for plaintiffs awarding attorney fees and costs and further relief as being just and proper by the court. Okay. And we demand a jury trial. Whew. All right. There you have it. Again, I did this really for educational purposes. I wanted you to see how this process works, what a lawsuit looks like, a federal lawsuit, and why you can sue state actors acting under the color of law who violate your federal constitutional rights. And I wanted to make sure you heard exactly what we're alleging. And you can read it yourself here at bernie.substack.com. That's where you can read it yourself. Thank you, by the way, to the Unknown Patriot for your support. And thank you, all of you, for your support as well, either at patreon.com/Bernie Thompson, which is like throwing a tip in the tip jar. It's easy, it's anonymous, and you can quit anytime. Or PayPal, Matthew. Thank you so much for your support. Did you catch that? At PayPal as well. All right, is that everything? I'm feeling a little loopy. You know mostly why? Because this is a big deal. And it's going to be exhausting. Lawsuits are not fun for anybody, except maybe the lawyers. It's going to be painful. It's going to be laborious. But and it's scary. But you know what I think? If we didn't file this lawsuit, we'd probably be in even more danger. Because with people who do this to other people, whether you're nice or whether, you criticize them, they're still going to beat you up. They're still going to hurt you. You can't nice your way out of bullies or tyrants. So I didn't really want to read this all to you today. But I thought it was necessary, and I'm glad I did. So again, I'm not going to. I'm going to try to fill you in with the facts as the lawsuit goes on. But out of respect for the court and the process, because that's all I have, we're not going to make a circus out of it. Although I'm sure, they'll have trolls trying to pretend, whatever. But you're going to learn a lot through the discovery process. The complaint doesn't tell everything that we have through public records that are going to shock you to your core. You will not believe what they did. But this is a federal complaint, and it's the first step of the process. So now they'll reply, and then discovery will begin, and it'll probably take a while. All right. As you can hear, I got to go. Thank you for being with me, and I will see you soon.